Okay, good morning, everyone. First order of business, there is a sign-up sheet going around so that everyone can go ahead and kindly sign in for us.
You took care of that already.
Oh, okay.
Okay, perfect. So my name is Clarissa Rodriguez, and I am the chair of the New York State Workers' Compensation Board. Thank you all for joining us today as we kick off the Independent Medical Examination Advisory Committee. We do appreciate that your time is valuable, so we do thank everyone for being here today, including our remote locations. So today we will discuss the statutory mandate, review the board's preliminary utilization study on independent medical examinations, or IME as I'll refer to them here on after, and discuss the next steps and future meetings. The utilization study we have prepared is based on the stakeholder feedback received throughout 2018, as well as data collected by the board since the legislation was enacted in 2017. As you know, in recent years, IMEs have been the subject of much scrutiny. Many concerns have been raised, including IME availability, the scheduling and timing issues, quality, and potential fraud. So before we get started, I'd like to mention that we are video conferencing with committee members in Rochester, White Plains, and Manhattan. So greetings once again to our remote attendees. Also a few housekeeping items before we get started for the general public here in Schenectady. There are 2 exits to this conference room, as you can see on this side of the wall. We also have a scheduled break, a 15-minute break, right after the IME study presentation. And lastly, there are restrooms right off of the elevators. So once the securities can direct you once we're on break. Okay. The next slide. Oh, you know what? We didn't work that out. Stephanie, you'll be my slide person. Thank you. So, as part of the 2017 budget bill, lawmakers added an amendment to Section 137 of the New York State Workers' Compensation Law, directing the board's chair to conduct a study in 2018 of the utilization of IMEs. It was also required that a preliminary study, which you will all receive today, be presented to an advisory committee. This committee consists of representatives of organized labor, business, carriers, self-insured employers, providers, and other stakeholders and experts, as you'll see momentarily. This advisory committee shall present by the end of the year a detailed recommendations to the governor, Speaker of the Assembly, and the Majority Leader of the Senate. Said recommendations should address administrative improvements as well as regulatory and statutory proposals that will ensure fairness and the highest medical quality while improving methods of combating fraud. A tall order indeed. Additionally, the committee's final report will consider the feasibility of new methods of assigning independent medical examinations through rotating providers or panels, statewide networks, or other arrangements as the committee sees fit. To develop your recommendations, this committee has been directed to review the board's preliminary report and analyze leading studies, both in New York State and nationally. Now that you have your charge, committee members, let's run through the members of the committee. Okay, including myself, there are 12 committee members. So when I mention your name, please acknowledge your presence, either here in Schenectady or at one of our remote locations, if you're participating in this meeting. So first, we have Brian Trick from Wegmans, self-insured employer.
I'm here.
Thank you, Brian. Next, we have Mindy Roller, Deputy Chief of the New York City Law Department's Workers' Compensation Division. New York City Law.
Chair, I just have to interrupt you.
Yes.
Ms. Roller is now the chief.
Oh, very well. Chief. Thank you. Yes, congrats. Third, we have Joe Canavas, New York City Labor, AFL-CIO.
Present.
Thank you. Next, we have Lev Ginsberg, New York City Business Council for Business.
New York State, but
New York State. New York State. That's right. It was on here as state, and that was my mistake. Thank you for being here today. Glenn Petruzzo, AmTrust. for
Hi,
insurance carriers.
This is Jeff Fenster. I'm sitting in for Glenn. He couldn't be here today, but he'll be at the future meetings.
That's right.
Nice to see everyone.
Thank you, Jeff. Thanks for joining us today. You're filling it as delegate on behalf of AmTrust. Thank you. Robert Sammons, New York State Insurance Fund, insurance carrier.
I'm here in White Plains.
Thank you. Welcome. Dr. Robert Goldberg, Medical Society of the State of New York, MISNY.
I'm here in Manhattan.
Thank you, Doctor. Dr. Winston Kwa, the Icahn School of Medicine at Mount Sinai, occupational medicine doctor and IME provider.
I'm here in White Plains.
Thank you, Doctor. Justin Teff of Kirk and Teff, injured workers attorney.
I am here.
Hi, Justin. Matt Mead of Stockton, Barker, and Mead, defense attorney.
Here.
Dr. Richard Weinstein, member of the New York State Society of Orthopedic Surgeons.
Here in White Plains.
Thank you, Doctor. And lastly, myself as chair. Okay. And also to ensure maximum productivity and that these meetings do run smoothly, the board has hired a facilitator, Michelle Cummings, to help conduct the advisory committee meetings. Michelle, would you kindly briefly introduce yourself?
Thank you, Clarissa. My name is Michelle Cummings. As Clarissa said, I'm currently at Rockefeller Institute in a number of different capacities. My governmental experience has been long and extensive, probably way too many years. But one of the things that I bring to, hope to facilitate in these discussions is my background as Deputy Commissioner of Tax Policy, where we put together a number of different task forces to issue specific or general tax policy groups on behalf of the Commissioner. So I'm looking forward to working with all of you to try to bring some type of recommendations or policy to take forth to the Governor's Office and the Legislature.
Okay, thank you so much and welcome, Michelle. Additionally, there are several subject matter experts at the board that may assist with the advisory committee when additional information is required. When I mention your name, please acknowledge your presence so that the advisory committee members know who you are. First, Mary Beth Woods, the board's executive director.
Hello, everybody.
Next, Steve Smith, the board's deputy executive director.
Here.
Third, David Wertheim, the board's general counsel.
Hello, everyone.
Fourth, Elaine Sobelberger, the board's medical director.
Hello, everyone. Good afternoon.
And last but not least, Stephanie Zufali, Director of Regulatory Affairs.
Hello.
Okay. And know that as other subject matter experts are needed, such as IME entities, we will ask them to attend subsequent meetings. Okay. Today we will get started by covering the background on IMEs in New York. We'll then look at the board's preliminary utilization study and the data it covers. We'll also go over the ground rules and what's expected of this advisory committee. We will confirm the meeting topics and the proposed timeline to deliver the mandated report by 2019. And so now let's just cover the basics of what is an IME. Now this will be a refresher for most of you, but do indulge me. So generally, when a worker is injured or becomes ill from work, the worker notifies their employer and goes to a board-authorized healthcare provider for medical evaluation and treatment. Thereafter, the employer should report the injury or illness to its carrier, and the injured worker should file a workers' compensation claim. The treating provider's report becomes the basis for the worker's benefits, which may include lost wages, medical treatment, and/or partial or permanent disability award, which are paid by the employer's workers' compensation carrier. Under the current workers' compensation law, the carrier may request an IME at any point after receiving the first treating provider's report. The IME can be either an in-person examination or a review of the injured worker's medical records. The results of the IME are submitted to the board and can then be used as evidence before the board in the event of a dispute between the carrier or injured worker. IMEs in New York are performed by independent medical examiners who possess a valid and unrestricted professional license granted by the New York State Board of Regents and are authorized by the board. With the exception that in limited situations, if an authorized IME provider is not available, an IME may be performed by an authorized medical provider, for example, an out-of-state provider. The board maintains a searchable database of all IME providers who are authorized and registered with the board. When a carrier requests an IME, they typically make the request to an IME entity. An IME entity is an individual or organization that employs or contracts with independent medical examiners to conduct examinations or records reviews. An IME entity acts as a referral service to facilitate such examinations and reviews. IME entities must be registered with the board, and a listing of authorized IME entities is also available at the board's website. The IME entity will then schedule an examination or a review of medical records with an authorized IME provider and will notify the interested parties of the date, time, and location of the examination and the name of the IME provider. After said examination, the IME provider, often through the use of the IME entity, will submit a report to the interested parties. The IME report is then used by the board in conjunction with the opinion of the injured worker's medical provider to render a decision about the medical issues in the claim. Now let's take a look at the common claim scenarios involving IMEs. The first is claim establishment or controversy, including death. IMEs may be requested to establish or deny a workers' compensation claim, fundamentally determining whether the worker's injury, illness, or death happened at or is causally related to his or her job. Next, you have medical-only issues. IMEs may be requested to capture the IME provider's opinion on variances from established medical treatment guidelines, including weaning from opioid pain medication. Next, we have award determinations. IMEs may also be requested when determining the benefit an injured worker will receive based on his or her injury or illness. There are several subcategories for these where an IME may play a role, including additional sites. These are done to determine whether injuries to the other body sites are causally related to the original injury, or temporary total and temporary partial awards. These are done to determine the injured worker's degree of disability, ability to return to work on light duty, or anything in between. These include IMEs that may serve as the basis for a request to suspend or reduce compensation. The next category of IMEs is the permanency classification, which includes schedule loss of use. These IMEs are done to determine the schedule loss of use award based on a worker's injury to and resulting permanent loss of use of a specific body part or parts. Classified permanent partial disability, or PPD. These are to determine an injured worker's degree of disability when he or she has reached maximum medical improvement, or MMI. And the last classification is permanent total disability, or PTD. This is to determine that an injured worker is permanently totally disabled. We can also have an IME for apportionment. These IMEs may be used to determine the percentage of liability of a work-related injury that can be apportioned to another established claim. Finally, IMEs may also be used to determine the date on which the occupational disease was contracted, as well as other aspects of the claim, such as causal relationship. Now, in this next slide, I hope will serve as like a quick reference guide or a cheat sheet, and it's comprised of the possible reasons for an IME based on the claim type. So you'll notice the first two reasons, causal relationship and consequential injury, are actually the most common.
Move it.
Move that.
I'll
Is there
see.
something in the way?
There we go.
Thanks.
That's good.
Okay. So as you can see, these may be requested when a claim is controverted in medical-only claims and cases involving either temporary or permanent disability. Medical variance, medical authorization, opioid weaning, or apportionment may prompt IME requests in medical-only cases and cases involving either temporary or permanent disability. At this juncture, the case is no longer being controverted, and it's likely already established. Similarly, IMEs to determine an injured worker's degree of disability or when they can return to work are typically requested in cases of temporary or permanent disability. Finally, an IME may be requested to determine if an injured worker is permanently totally disabled. Permanency may be initiated by either a treating provider or an IME provider, and if the injured worker's doctor's report of IME/permanent impairment first raises permanency. At this point, the carrier may schedule an IME. Quickly, let's review the IME process. Now that we've gone over the IMEs and the reasons for them, this is a flow chart of how the process works. So starting with first box, letter A, almost all IMEs are requested by carriers, and those carriers typically make the request to an IME entity, like I stated earlier. Next, the IME entity will schedule an examination or a review of medical records with an IME provider. And as depicted in the box 3, the entity will then notify the injured worker and the board of the date, time, and location of the examination, and the IME provider's name via the claimant's Notice of Independent Medical Examination, which is Form IME 5. Injured workers must be given at least 7 days' notice of their exam date and time. At letter B of the flow chart, if the IME is performed, the IME provider, often through the use of the IME, will submit a report. The independent examiner's report of independent medical examination, which is Form IME 4, and this will be submitted to all interested parties. For IMEs within New York State, the IME report must be received by the board within 10 business days of the exam. For out-of-state exams, it must be received within 20 business days. This brings us to letter C of the flow chart. Once received, the board reviews the report and, as we mentioned earlier, uses it in conjunction with the opinion of the injured worker's medical provider to render a decision about medical issues in the claim. If an IME report is found to be defective, the board may actually preclude it. The board may also preclude the report if it is not submitted timely. Now back to letter B. If the IME is not performed for any reason, maybe it is canceled or the injured worker fails to appear, the process starts all over again with rescheduling the IME and sending a new IME 5. The injured worker must again be given another 7 days notice of the rescheduled date and time. Okay, now I will turn the presentation over to Stephanie Zufali to present the IME utilization study and provide you with a high-level overview of our key observations. We will give you a copy of the study before you leave today, so please hold your questions on the data until after you have reviewed the full study. Throughout the upcoming year, as the advisory committee reviews each IME topic, there will be ample opportunity to ask any questions you may have about today's presentation and any other information in the study. Okay, thank you, and go ahead, Stephanie.
Okay, thank you, Clarissa. In mid-2017, the board began a comprehensive assessment of utilization of IMEs in New York State. The board receives over 250,000 paper IME reports each year, which is related to 160,000 unique IMEs. Although these reports are scanned into the board system, there's very little data captured. Therefore, to conduct the utilization study, several data collection methods were used. The board conducted a labor-intensive process to collect and cull the necessary data for this study, including collaborating with the New York Compensation Insurance Rating Board, performing manual record reviews, conducting numerous stakeholder interviews, requesting and validating data shared by IME entities, and creating and compiling injured worker surveys. Additionally, the board developed a state-by-state comparison of IME statutes. First, we worked with NYSERB. The board shared IME data, permanency indicators, lost time indicators, and medical treatment guideline variance indicators with NYSERB in an effort to correlate the indemnity and medical cost with IMEs. Although NYSERB could partially match the data, it was inadequate to report on system costs. So next, we performed a manual review of 2,000 IME records from 2014 to 2016 for cases that had a permanency classification and that were closed. Although we manually gathered approximately 30 fields of data for each case, we determined that additional data was needed to respond to concerns raised by stakeholders. Throughout 2018, the board held numerous stakeholder calls to seek input on key issues and concerns regarding IMEs. Stakeholder groups included representatives of organized labor, business, carriers, self-insured employers, medical providers, IME entities, and injured worker and defense attorneys. Recurring themes include provider access, timing and scheduling difficulties, injured worker experience, costs, quality of reports, fraud and abuse, and process issues. To research stakeholder concerns, we needed more data. So in March of 2018, the board reached out to all registered IME entities to request 2014 through 2016 data for the study. We received data from 50 entities, which was then scrubbed and validated to the extent possible with claims data in our system. The data we received represents approximately 80% of all IME records. Finally, we conducted an injured worker survey. The board reached out to a random sample of 375 injured workers for whom the board received an IME-4 dated August 2018 to obtain their perspective on the IME. The surveys were entirely voluntary, and we assured injured workers that their responses would not affect their claims in any manner. The board translated 34 of the IME surveys into 8 different languages, and we received and compiled 110 responses. Finally, the board also prepared a comparison of IME statutes in other states. So before we get into the details of the study, here are some high-level statistics to help provide some context for the upcoming slides. On average, 160,000 IMEs are performed each year. As I mentioned earlier, we receive approximately 250,000 IME reports each year. The additional 90,000 reports are due to duplicates and addendums. On average, approximately 1 in 3, or 30% of claims, will have at least one IME over the life of the claim. This varies significantly based on the type of case. For example, 16% of medical only, 76% of schedule loss use, and 96% of permanent partial or permanent total cases have at least one IME. 94% of IMEs were for in-person exams, and the remaining 6% were for record reviews. And finally, orthopedic surgeons performed 80% of the IMEs, followed by 5% done by psychiatrists or neurologists, 4% by physical medicine or rehab physicians, and 3% by chiropractors. As I previously mentioned, there are several categories of recurring concerns raised by stakeholders. Today, I will provide a high-level summary of each of the 5 categories: provider access, scheduling and timing, injured worker experience, cost of IMEs, and quality of reports, follow-up, and duplicates. Each of these sections will be more fully discussed throughout the upcoming year. For example, for provider access, the provider access slides will be reviewed again in a subsequent meeting, at which time we can answer your questions about the data and use the study data to guide our discussions on the topic. So, starting with the provider access category, you'll note that the number of authorized IME providers has decreased slightly over the past 5 years, ranging from a high of 8,137 in August 2012 to 7,735 in August 2018. As of December 1st, 2018, approximately 3,350 IME providers who failed to re-register with the board were suspended from performing IMEs. Although this appears to be a significant decline, the following slides demonstrate that only 27% of authorized IME providers actually performed IMEs during the 2014 to 2016 study period. This slide shows the percentage of authorized IME providers who actually performed IMEs during the 2014 to 2016 study period. The yellow bars show the count of those IME providers who performed one or more IMEs. For example, for orthopedic surgeons, which is the top bar on the chart, approximately 79% of the 671 providers performed IMEs, whereas for chiropractors, the next highest IME provider type, only 21% of the 1,670 providers performed IMEs. A total of 2,089 authorized IME providers submitted at least one IME during the study period. The next slide will show where these IME providers are performing IMEs in New York State. So in this slide, the darker colored counties had the highest count of IME providers performing services, again during 2014 to 2016. Lighter colored counties had proportionately fewer. The highest counts are downstate in Nassau and Suffolk counties. There were no IME providers who performed IMEs in 3 counties, Hamilton, Yates, and Tioga. It should be noted that some IME providers travel and perform IMEs in several counties. Thus, some of the IME providers are counted multiple times in this graph. The next slide shows the count of authorized providers who performed one or more IMEs during 2014 to 2016. A total of 2,089 board-authorized providers performed IMEs. 122 of these providers, those that are in the first row of the table, were only authorized to perform IMEs. The remaining 1,967 were authorized by the board to both treat and perform IMEs. The last column shows the percentage of IMEs performed by each provider type. 86.5% of all IMEs during the study period were performed by IMEs who also actively treated. 13.3% of IMEs were performed by the 122 providers who were authorized exclusively to perform IMEs. This slide shows the frequency that IME providers performed IMEs, as well as the overall count of how many IMEs they performed. The first IME range of 1 to 5 IMEs, which is the first line of the table, had the largest count of providers, 2,889, representing over 70% of all IME providers. These providers performed 5,130 IMEs, slightly over 1% of all IMEs during the study period. Conversely, if you look at the last 2 rows of the table, there were 104 IME providers, approximately 2.5% of all IME providers, who each performed over 1,000 IMEs during the study period. This equals 72% of all IMEs. Note that the total number of IME providers on this slide totals 4,089. This count of IME providers is higher than shown in earlier slides, since it includes 2,000 providers who submitted IME4 reports but who are not board authorized. Although this is a large number of IME providers, this subset of IME providers performed less than 1% of all IMEs. So to summarize, 70% do 1% of the exams, 2.5% do 72%. We understand that this slide shows many numbers and percentages, and it's a lot of information to try to understand. As we discuss individual topics at future meetings, we'll get into the details and answer any questions that you may have. Next, I will move along to the scheduling and timing issues. The chair briefly discussed the process flow for scheduling an IME. That slide is repeated here. Using the IME entity data, the board analyzed certain timing and scheduling concerns. First, we show the average days that it takes to schedule an IME from the date that the carrier requested the IME to the date the IME was held, from A to B in this chart. On average, it takes 34 days to schedule an IME. However, this varies by specialty. For chiropractors, the average is 28 days, and for pain management providers, the average is 44 days. Next, we show the average days it takes for the board to receive the completed IME4 report, which is from B to C. It's the difference between the date that the IME exam occurred to the date the report is filed with the board. On average, it takes 14 days for the board to receive the IME4 report. As previously mentioned by regulation, in-state IME reports are required to be received within 10 business days. This typically equates to 12 to 14 calendar days, depending on what day of the week the IME occurred. From start to finish, from A to C on the slide, from the date the carrier requests an IME to the date received by the board, the average is 46 days. The last two statistics up in the upper right corner on the slide are the no-show rate and the cancellation rate. On average, 9% of scheduled IMEs have a no-show, and an additional 14% are canceled prior to the date of the exam. Combined, 23% of IMEs require rescheduling. Next, I will present data on the injured worker experience. So the next series of slides are outcomes from the injured worker survey. As touched on earlier, the survey was sent out to 375 injured workers who had an IME during August 2018. The sample was randomly selected from over 14,000 IMEs performed in August and received by the board through mid-October. 34 of the 375 injured workers preferred a language other than English, so the board translated the letter, survey document, and online survey into 8 other languages, including Spanish, Armenian, Fuzhou, Korean, Nepalese, Polish, Portuguese, and Punjabi. The surveys were mailed out in late October. Recipients were advised that the survey was entirely voluntary and that it would have no impact on their claim. The board received 110 responses by the time we closed the survey in early January. The following series of charts will show the summarized survey responses. So injured workers were asked, was the medical office in a convenient and accessible location within a reasonable distance from your residence? Approximately 2/3 of responses indicated the IME location was convenient and accessible. Next, injured workers were asked, was the medical office clean? 90% responded that the medical office was clean. Next, they were asked, approximately how long did you wait at the office before you were seen by the IME provider? Approximately 2/3 of those responding recalled that they waited 16 minutes or more before being seen by the IME provider. Next, injured workers were asked approximately how long did the examination take. 48% of injured workers estimated that their IME was performed in less than 15 minutes. Next, injured workers were asked, did the office staff and IME provider act in a professional manner? Over 80% of those responding indicated that the office staff and their IME provider acted in a professional manner. Finally, injured workers were asked, do you believe that the IME-4 report submitted by the IME provider is a fair representation of your examination? More than half believed that the IME report prepared by the IME provider was not a fair representation of the exam. Next, I will discuss cost data. This table shows that the average, minimum, and maximum IME cost by IME provider specialty. The average IME provider fee for all specialties was $571. Both chiropractors and orthopedic surgeons had average IME fees that were below the combined average. Other specialties, such as psychology, had much higher average fees. The fees for psychology IMEs averaged $1,001. The minimum and maximum IME fees also varied widely for all specialties. For orthopedic surgeons, for example, the minimum payment was $105 and the maximum payment was $7,600. This slide shows available data on no-show fees. There was limited information about no-show fees in the IME entity data. This chart shows that for more than half of no-shows, which is the right side of the pie chart, IME providers do not receive any fee. Approximately 24% receive up to $100, 14% receive between $101 and $250, and 10% receive over $250. If there is a fee paid to an IME provider for a no-show, the average is $204. Next, I'll move on to quality concerns. This slide shows the distribution of IMEs received by the board. For every 100 IME-4 reports received, approximately 57, the large blue, light blue section of the pie chart, have no issues. 29 are duplicates, 13 are an addendum, and 1% is precluded. First, I'll discuss duplicates. Over the last several years, the duplicate rate has decreased steadily from a high in 2014 of 49% of all IMEs to the current 2018 rate of 29%. An IME report is considered a duplicate. It is for the same injured worker on the same date of service from the same IME provider. Addendums were removed from the duplicate submission counts shown in this graph. Regarding addendums, each year of the study had a 13% addendum rate. As you may know, in 2019, the board clarified that IME entities are prohibited from discussing, instructing, or directing an IME provider as to his or her opinions or finding in the IME report. This means
2009.
Oh, I'm sorry, 2009, yes. If the IME provider does not address all the issues requested by the carriers or addresses issues that were not requested by the carrier, a written request for an addendum may be made to the IME provider. The last category in the chart, the small yellow sliver, or maybe orange actually, represents preclusions, which are estimated at 1%. Previously, when the chair discussed the IME process, it was mentioned that an IME report may be precluded if it's not timely filed. It could also be precluded if the IME report was not properly served on the same day in the same manner. The board does not track preclusion rates, but for the purpose of this study was able to capture instances where the word precluded was used in a workers' comp law judge decision. We estimate the preclusion rate is between 0.5% and 2%. For this chart, we use the midpoint of approximately 1%. We believe that the 2% overstates the actual preclusion rate because it includes scenarios where a workers' comp law judge is warning a carrier that they are precluded from producing an IME that's not actually in the file, as opposed to precluding one that is in the file. Finally, there are also situations where an injured worker was provided notice that an IME was scheduled, but the board does not receive the subsequent IME report. For the study period 2014 to 2016, the board received 32% more IME 5s than IME 4s. As discussed previously, approximately 23% of scheduled exams result in a no-show or cancellation. So as depicted in the pie chart, for every 100 IMEs scheduled, the board receives 68 IME 4 reports, the large light blue section of the pie chart. 14 are canceled, 9 have a no-show, and the remaining 9 are unaccounted for. There are a variety.
Can I ask a question? What is the difference between IME 4 and IME 5?
The IME 4 is the actual report of what occurred during the examination, and the IME 5 is the notice that is sent to the claimant to let them know when their examination is scheduled. So there are a variety of reasons why there could be some IME 4s that are unaccounted for, including settling prior to submission or a deliberate decision not to submit. This last slide in the quality section shows the frequency of IME 3 report submissions. As you may know, parties are not allowed to have offline communications regarding IMEs with the providers. The board issued clarification that explains how and when carriers may communicate with IME providers. The IME 3 form is used to convey questions the carrier wants the IME provider to address or to ask follow-up questions after an IME report is submitted. It's important to note that 29% of the IME 4 reports filed did not have an IME 3 associated with them. Therefore, only 71% of the cases submitted an IME 3. Of that population, 55% had only one IME 3 request. The remaining 45% required multiple IME 3s, often after the first IME 4. Next, I will discuss the state-by-state comparison. It's important to note that there's no reliable national IME data available to comparatively evaluate utilization, costs, and procedures. The 2015 IA-IABC study is included as an appendix to the study, but it presents information only on 27 states. Therefore, the board reviewed other states' statutory frameworks to further our study. There were challenges when compiling this information due to discrepancies in terminology and limited availability of detailed IME procedural information. The information that we were able to compile includes the following categories: the term each state uses to reference their IMEs, provider qualifications, the state authorization or qualification process, how an IME provider is selected to perform an exam, the time frame to submit IME reports, how IME providers are paid, including payments for no-shows, and finally, consequences of a defective IME report. We will discuss the state-by-state comparison as needed as we continue our meetings. The detailed comparison state-by-state is included in Appendix 5 of the study. Finally, there were other issues raised by stakeholders that the board was unable to quantify, but they fall into 4 broad categories. These other issues include topics such as fraud and abuse, credibility of an IME versus a record review, regulations, and training. These topics will also be discussed as part of future advisory committee meetings. Now I will turn it back over to Clarissa to wrap up the study and to discuss future meetings.
Thank you, Stephanie. And thank you to all of the board staff who contributed to the IME study. As previously mentioned, Stephanie presented a high-level review of the report. Each topic or section of the study will be discussed in greater detail at future meetings of the advisory committee. For example, at the meeting covering provider issues, the provider data will be reviewed again. And at that point, we will answer your questions and use the data to guide our discussions on the topic. A full schedule of meetings and topics will be discussed momentarily. Now, before we get into specifics of meetings and topics, let's talk about the ground rules. And for that, I will now turn it over to Michelle Cummings.
Thank you. As Clarissa indicated and Stephanie reported, you can see that there is a whole host of topics that need to be covered under a very short time frame. The beauty of having the meetings facilitated, this task force is very different from other task forces that have been, set up in statute, in that most of the time the task force will report to the commissioner, who then produces the report. This one is very different in that the report is yours. The report is meant to reflect all of your different interests, and what comes of it we will see over the next 12 months, which is one of the reasons why they have someone a little bit independent, helping facilitate the meetings. The goal is to have everyone's voice heard. They are open meetings, open to the public. However, we do ask that the committee members, to make sure everybody who is intended to be represented, be the ones that speak at the meetings. The schedule is going to be based on the topics as we have identified, and I'm going to run through those shortly. But as we move forward with meetings, we ask that you stay on topic for that meeting. We'll either parking lot it, move it to another time. Again, be assured that your opinions do matter. Unless, it's completely out of scope. It is a very broad agenda, and we will move that to a different table. You're all busy people. We're all busy people. You'll have to travel here, whether you're in White Plains, Manhattan, Rochester, or Schenectady. Once we have agreed upon the best schedule, if you can't be here, please send a delegate. The meetings will be posted online, but to ensure that your voice is heard, it's in your best interest to, send someone to represent whoever it is you're representing. So based on the...
Michelle, just one other point. We will have a shared mailbox to collect your questions or comments. If you want to send those before the meeting, or if there's any data requests or whatever you need. As soon as that mailbox is up and running, we'll notify you of the address so that you have it for future meetings.
Thank you. Okay, so you want to go to the next slide?
Sure.
These are the major categories of concern that were raised during the outreach over the past 12 to 18 months. We'd like to discuss each of these categories thoroughly at a future advisory committee meeting. Today, I will go through each category to identify proposed agenda topics to be discussed at future advisory committee meetings. Again, this list is a reflection of what the staff members heard over the last 12 months. We will hand out a copy of this once I'm done, and then take a short 15-minute break, at which point in time I'd like you all to review it. If there's something you believe you did address that we did not include, by all means, after the break, we'll reconvene and capture your feedback. So the 7 proposed agenda topics are provider access, scheduling and timing, injured worker experience, cost of IMEs, quality of reports, need for follow-up and duplicate filings, fraud and abuse, and process. So the first topic, which we are proposing for discussion at our next meeting, is the topics for our IME providers. We divided the provider stakeholder concerns into 3 broad categories: availability, quality of exams and providers, and miscellaneous. Under the availability category, we've identified 2 subcategories that are upstate versus downstate and not board authorized. Under the quality and exam provider, we've identified 5 subcategories here. The first is credibility of reports, which covers 4 types of reports: carrier IME, injured worker treating, injured worker IME, and records review. And finally, the other 4 subcategories all come under the quality of exam and providers, and they are the IME mills. IME non-referral list, exam preparation, file review, training, and the miscellaneous, you always have to have one, is any issues discussing overseas versus US-based record reviews. All of these, as I said, are topics that we would target for the meeting on IME providers. The next category is topics for scheduling, in which we've identified 2, scheduling and reports. Under scheduling, the proposed subtopics are self-initiated, no deadline, versus directed or required, with a deadline imposed, specialty providers availability, notice, 7 days, cancellations, and no-shows. And then under the second category, it would be 10 business days under reports, 20 days out of state, and the same day, same manner requirement. Under topics for injured worker experience, there are 7 broad categories: location, professionalism, wait times, duration of IME, accuracy of the opinion per the injured worker, recording of exams, and education regarding Ime process and outcomes. Under topics for Ime costs, we identified 5 proposed topics: no Ime fee schedule, wide range of reimbursement by specialty group, no policy on cancellations and no-show fees, same day, same matter cost, and reimbursement for precluded IME reports and out-of-state IME fees. Topics for reports, follow-up, and duplicate filings. There are 5 main categories of concerns as expressed in last year's discussions. They include IME preclusions, accuracy of POIs, duplicate submissions, IME performed but not filed with the board, and addendums. And under the addendums category, there are 3 subcategories, which include frequency, scope, including minor clarifications, and new issues, additional clarification, and communication. Topics for fraud and abuse. Another meeting will cover role of the fraud inspector general, under and over reporting conditions and capability, failure to disclose, and misconduct by IME provider. And then finally, topics for process. We have identified 4 main categories of stakeholder concerns. The first is state physician versus IME panels versus PPOs, records review versus IME, regulation and monitoring, and same day, same manner. And with the regulation and monitoring category, there will be 2 subcategories: IME providers and IME entities, including accreditation and reporting. So this, as I said, is essentially, what the staff pulled from all of the conversations that included with all of you over the past several months. At this point, we're going to take a break and hand out to you a piece of paper that's going to list all these. To the extent we did not include something that you feel you stressed or you thought of after the fact, we're going to ask you to write that down during the break. And then when we come back, we'll talk about next steps. And just as a reminder, the exits are here and the restrooms are out through the door. That's it. No, that's a
I
break.
think that's fine. So we'll take a 15-minute break now.
At this point, what we'd like to do is turn it over to the committee members. And I would suggest us going around the room. If you could identify yourself, who you're representing, and to the extent you have indicated or identified an issue that we may not have covered on the slides that you would want to make sure is covered as we move forward, you let us know that. And we're not going to do notes because these meetings are videotaped. We'll be able to review them, so that is in effect becomes our notes. So.
And just one other thing, we have allotted about an hour for this discussion, so don't necessarily feel rushed. But if, like she said, if there's anything that you think we've missed or you'd like the IME study to cover, or for us to go more in depth in any topic in particular that you think should be added to these suggested topics, please let us know. Now is your time to do so.
All right, so maybe we could start with Mindy. Sorry, someone has to go first.
Okay.
Mindy, you could identify yourself.
Sure. Mindy Roller from the New York City Law Department. City of New York is a self-insured and self-administered employer. And I think this is a pretty comprehensive list. I have no doubt that as we proceed, other topics may arise, as outgrowths of this, but I think this is an excellent starting point. Thank you.
Thank you, Mindy.
Lev Ginsberg with the New York State Business Council. We represent about 2,300 to 2,400 businesses throughout the state, all sizes. We represent self-insured, we represent insured entities, and we represent insurers. So there's sort of we have a lot of interest, obviously, in this. I would echo Mindy saying this is a very comprehensive list. I would commend the board on the study, and I would say that I was actually pleasantly surprised with a number of the findings that I think that you guys elaborated, especially the survey results that seem to indicate that overall it's a much more positive experience than a negative. I would have imagined those numbers have been not as kind. But as we go on, there might be additional stuff. My one concern is that I don't know how I would put it in one of these categories, but I think it's important as we're going down the road and looking in these silos that we don't forget that these are adversarial proceedings, not this necessarily, but that the IMEs are part of an adversarial proceeding, and that it's not necessarily apples and oranges to be looking at experiences in tort when it comes to things like this. This is not a world of its own simply because we're talking about it in the workers' comp space. And I don't know how we would accurately reflect that in this list, but something to sort of keep in mind as an overlay as we go forward.
My name is Matthew Mead from Stockton, Barker & Mead. I'm here, I think, as a defense attorney. My firm represents employers, carriers, and third-party administrators. I don't have anything that I'd like added to the list, but I have a question about what one item on the list means. Can I ask that now?
Sure.
Under providers, there's an item third from the bottom that says IME non-referral list. I don't know what that means. It's not something that exists now. I don't think. Is it something that is?
Matthew, we, in stakeholder interview calls that we had, we were told more than once that carriers have a list of IME providers that they choose not to use. And so that is what
That's
we're
what it's
referring
referring
to,
to.
for
Okay.
whatever reason.
Okay. Whatever reason.
Thank you.
Yep.
Good question.
My name is Justin Teff. I'm a claimant's attorney with the firm of Kirk and Teff. I'm immediate past president of the New York Injured Workers Bar Association, so presumably my function here will be to introduce part of the claimant's bar's perspective to the proceedings. I too do like the list. The only thing I would suggest either adding to it or a topic that can be discussed in the course of the meetings, there's a topic under quality of exams and providers, which is exam preparation. Because of where it's listed, I take that to mean preparation by the examiner for the exam, but I could be wrong, and forgive me if I am. The suggested topic or matter for thought would be the claimant's bar's concern that there may at times be a disconnect between the IME examiner, what they have written in the report, and what ultimately winds up in a IME vendor's submission to the board. Not that anything has necessarily been fraudulent in the course of that, but things at times are lost in translation via the use of checklists or other materials that sometimes are utilized in the course of these. I would like that to be a subject for consideration, and if it turns out that there really are no issues in that regard, so be it. But if there are, worthy of discussion. And that is all I would add.
So Justin, in the fraud and abuse section, we do have the category misconduct by IME provider, so that could perhaps cover that area.
That's absolutely fine. Thank you very much.
If I might add.
Sure.
If you might add a slash there for misconduct by IME provider / IME entity.
I did not want to be that in, but Mr. Mead, being very experienced and having done this many years, that actually would have been my suggestion, because I'm not suggesting that the provider is necessarily responsible for what might be a concern. Again, sometimes things are lost in translation, or there may be issues on the part of the vendor, but that actually is more the focus is perhaps the vendor, less the provider.
Thank you, Justin.
Hi, I'm Joe Cannabis, Special Counsel to the New York State AFL-CIO. New York State AFL-CIO represents about 3,500 local unions, which in turn represent about 2.5 million members across the state. Before I go any further, I want to thank the chair, the executive director, and their staff, the Workers' Compensation Board. It seems just from this relatively brief presentation that a lot of work has gone into that, and it's appreciated. Thank you all. As far as comments on the upcoming topics and a little bit of what we saw this morning, one of the things that seems to be missing is the idea of bias. I don't think that any skewed outcomes or all skewed outcomes can be attributed to fraud or abuse. You know, we've seen, I'm a lawyer, so I take my own experience. We've seen in the last couple of years at the Bar Association and the CLE board, we now have to take CLEs on implicit bias. That's now one of the required topics. I think that we should be looking into bias in IME reports and possibly also exploring some of the reasons for that bias. You know, are the people who are conducting these IMEs dependent on this line of business to make their living, or is it something that they do a couple times a week? I'm also interested in diving a little bit deeper to see the correlations in the data. One of the slides, I don't have it here, but one of the slides made it pretty clear that a very few people are conducting the vast majority of these IMEs. It would be interesting to see how those folks compare to some of the earlier stats that were provided. The other thing that I would be interested to see is what precisely were the questions asked of the injured workers. It seemed to me we only got 3 or 4 words about each of the questions, and there were only about 4. I'd be interested to know if they were asked about pain or discomfort that they may have experienced from being physically forced during the IME exams. The last mention I'll make is From my perspective, the injured worker treating reports might be a little bit beyond the scope of the legislation and the purview of this group, and I will leave it at that. Thank you.
Okay, thank you. Is there anyone else
Oh.
here?
Okay, we'll start with Manhattan.
Okay, hi, Robert Goldberg. I'd like to go first. When I heard the process behind the compilation of this report, I want to echo what Joe said. To do this by hand for 250 plus reports per year, counting the dupes, is astonishing. I can't imagine that it was done, and I'm blown away by it. One thing but I have a number of questions. One is, what is an IME? And when we looked at the slide which talked about the no-shows, and then we talk about spontaneous IMEs, then I'm beginning to think that what we're looking at in some of these is something being billed as an IME, but is really just a C4 form with a schedule loss of use determining permanency, being deemed an IME and being billed accordingly. So I'm unclear if that's what's happening, because if it is, it's going to skew the data. It skews it in a number of ways. One is the no-show. If a doctor decides one day as a treating physician to perform something that he's going to call an IME, well, then there are no no-shows to that. So that 23% no-show, in my experience, is low. I believe it's going to be higher than that, and I don't know what that is, and perhaps we can flush that out. The next one is, we talk about provider access. I'm a former dean of a medical school. I never went to provider school. I haven't met a physician who operates or takes care of an injured worker who went to provider school. I would like to see this read physician access and then others, because it's very important to distinguish between them, because physicians are trained in the ability to perform an independent medical exam. It's part of the scope of the training of many of the groups that you saw: orthopedic surgery, neurology, physical medicine, rehabilitation. I can't speak for the others that are non-physicians, and please don't put us in that same group that is a technique used to show that there is access when we need to look at the reasons why physicians are not participating. We talk about experience in the room, and I think Lev hit it, that's an important one. One of the things that physicians have been able to do is we are taking out patient surveys for any encounter that deals with opiates. Because any patient that does not get the desired amount of oxycodone, Vicodin, or Percocet dislikes that experience. So if we can look at these encounters and take out the survey from anyone that had to do with a controlled substance, I believe we'd have a more accurate number. And then that number, I think, will actually skew quite nicely, that the 53% is going to go up. I mean, that's going to go down, and the satisfaction rate is going to go up. Satisfaction is low when opiates come in.
I'm sorry, Dr. Goldberg? Just
Yes.
a point of clarification. So you're saying that when, I'm just trying to get clarification on the opioids. Is that because you're saying if it's related to pain management, it would skew the 53% of the satisfaction rate with the IME? I'm sorry.
Let me rephrase it. Physicians have asked that patient satisfaction surveys be scrubbed. And scrubbed in a way that if opiates or requests for continued controlled substances is at issue, those surveys do not count if a patient, because too many patients are unsatisfied if they do not get a desired amount of drug. Without having the slide in front of me, I think 53% did not accurately reflect who and what they were. If we take the opiates out, that number would be more reflective of a positive experience than a negative experience. They should not be here, because a physician who wants to have a positive experience will just write more opiates, and that's what happened over the years when that was used for part of their data.
Okay, thank you.
Okay. The other thing is we talked about exam preparation. One of the things that I've raised in the meetings, and by the way, for those that don't have the history, I first became engaged in this process in 2007 with the medical treatment guidelines, and Mary Beth and Elaine Silverberger and I have worked very closely on these, and these things come up a lot. And one of the things that we have asked for, and Joe won't like this, and that's record access. physicians are asked to do an independent medical exam based upon the records that are provided, but I will maintain that we are not provided with all the records. We do not know priors, we do not know subsequent injuries, we do not know if the same body part had been injured. But yet we're being asked to render an opinion as to accident notice and causal relationship without complete background. And then the board is surprised that there's a number of addendums that are requested, in my mind, essential and necessary. Access to the medical file is something that physicians should have in order to be able to properly and in one sitting do it. I have to also agree that with that one slide where 10%, where 10 doctors, not 10%, 10 individuals are responsible for, can we go to that slide? I think if we just start with that slide, that'll solve our problems.
We only need one meeting? We're done?
Just one meeting.
You guys are good.
I'm getting excited. Here we go. Take a look at this. 10 of them did 65,000. So we break it to 3 years. So we're going to make it 22,000 IMEs. So working 7 days a week. Mr. Fensick did the math. It's 7 a day. And since they're only doing it for 2 days, they're doing 30 or 40 a day. And that's filing the report and proofing it and sending it. Come on. What is that? So when we look at that, and then the other one, which is also telling the slide, is 1 to 5 per doc. Well, this is underscoring the need for education and comprehensive education. I believe if those docs that are doing 1 to 5, which have 2,800 plus docs, if they understood what was required, what's necessary, what's desired, that number could then go up, and we could then adjust it. And I hope we're spending about 7 meetings in the bottom 2 to 3 of this slide here to fix the problem. Because if somebody is doing that many, they're doing it for a reason. They're satisfying the need of one entity. And I have, in my mind, an idea as to who or what that might be, but I'm not sure it's going to be fair to all the stakeholders, and that has to be addressed. And I'm very glad that Joe talked about bias, and I want to add a word, blinding, to it. Perhaps if a request, and then this is going to a solution, and I'm a doctor, we're always solving things even before we understand the whole problem, so I'm guilty. But if a need for an IME is identified, a request is made of a rotating data bank, so that the referral to an individual would be based upon need and not their desire for an outcome, I believe the number of IMEs would drop, the quality would improve, and the bias would be addressed, because one would not know when a patient shows up into a doctor's office for an IME if it's being requested by the carrier, a defense attorney, or a treating doctor who wants another idea. Thank you for letting me voice a few opinions.
Thank you.
Thank you. We appreciate that.
You're welcome.
So I'm Jeff Fenster. I'm representing AmTrust Financial. We are over the last several years, been one of the 3 largest private insurers writing workers' compensation in the state of New York. I really appreciate the opportunity to have AmTrust on the committee. I want to thank the chair and commend the chair and the whole staff of the Workers' Comp Board for the incredible presentation, the incredible job. To distill all this data and knowing the systems and everything down to this level of, presentation is an incredible effort, and really commend everyone that worked on it, and it's really impressive, and I think going to bear a lot of fruit for the state of New York, so congratulations. I just have a few minor comments. I would say maybe 3 things. One is, I think it would be interesting, this slide that's up now, we were debating it for the last 30 minutes. I mean, this is a concerning slide, and I think, thinking about how this slide, if you think about the claimant survey and where on this spectrum the claimants that are having good experiences, what doctors they're seeing on this slide, I think is an interesting thing to think about. So not necessarily that exact comparison, but thinking about this slide and how it relates to the claimant experience ultimately in the system, I think is something important to think about. I would echo Dr. Goldberg's views on non-physician, non-doctor providers within the IME system, and I think it might make some sense to look at them at least in some of the lenses we're looking through differently. If people are getting different service, different results, et cetera, by non-physician, non-doctor providers, and then perhaps the role of opioids and how IMEs interact with opioids has kind of become very quickly over the last 10 years been a really emerging topic, and I'm not sure, and I'm speaking for myself, so I don't mean to disparage anyone else, fully understand how opioids fit into problems that may arise within the IME system, and what types of cases involving opioids are being referred to IMEs and how that's playing out. I don't really fully understand that, admittedly, but perhaps there's something to be done there or to talk about. And the last I would say is, speak for the things I just threw out and others, I think this committee has the opportunity to do a lot of really good work for the system and for injured workers and employers in the state. And I would just caution everyone, or my own caution, if we throw out too many things and are too widely focused, and we would allow the perfect to get in the way of doing very good. So my view would be, I think it's a very good list. I think there's some good input here, and I look forward to working with everyone to kind of get the system improved. And I think everyone in this committee hopefully has the same goal. So those are my comments.
Okay, and before we leave New York, I would also like to do a shout out to Steve Smith, who has also been incredibly useful, important, and valuable in the work that we've been doing to improve the care and treatment for the injured worker. See, Steve, I see you in the back. I can't believe that Mary Beth is blocking you.
Thank you. Okay, Rochester?
Yes, thank you. My name is Brian Trick. I work for Wegmans Food Markets. I'm here representing self-insured employers. And I also want to thank everybody for letting me be part of this committee and for all the great work that's already been done. I have just a few comments. I think the list is great. I think if this is the order we're going in, I think we may have it a little off. And I think process maybe should be the one we start with, because I think if we fix the process first, some other things maybe fall off the table. I'll give you an example. And as many people in that room and on the call know that I'm a strong advocate of the preferred provider organization rule in New York. We take advantage of that in every area we can. And I think that is something that I see across 7 states we deal with. I have the ability to see what the impact of directing care is. And I think it's important for us to look at that. And I think, to me, the answer is crystal clear on where we need to go. We talk about all these things about IMEs and all the issues, the slide up there about 10 providers doing all these IMEs. Well, the perfect system really would be to not have to do IMEs. So I think if you look at the process first, it might take away some of all the other things that we have listed down here. And I'll just give you a few stats, and I think maybe we can get some more stats from our folks at the comp board. It'd be great is the amount of IMEs done with employees that go to a PPO. I can tell you from our experience, it's less than 5% of employees claims that are in a PPO, even for 30 days, only 5% of them have IMEs. I can tell you in other states like New Jersey, we've done 1 IME in 20 years. It's a lifetime direction of care. Virginia, we do about 4 IMEs per year. So again, if the goal is to make IMEs better, the best way to make IMEs is to make them go away, in my mind. And that's done by having providers that understand occupational health, that can understand causal relationship early on and get the employee in the right level of care at the right time. So we can talk more about that as we go along. I have a lot more I can say about that, but just I think the order to me would be the process. Let's fix the process first, and everything else might fall out of line or into line. So thank you for your time.
Thank you. Okay, thank you. Okay, and last but not least, White Plains. Who wants to go first?
I guess I'll go first. Bob Sammons with the State Insurance Fund. I think it's a very concise list. I'm looking forward to diving into the data. The slide that is in front of us, it's number 18, is very, very shocking, actually. And a lot of the items on the list echo what my staff and my people have said to me. Some of the things we are very worried about are provider access, scheduling and timing, but really of utmost importance to us is the quality of the IME report. You know, the word was mentioned that workers' comp, it's always been mentioned as being adversarial in nature. But the one thing about workers' comp that's not adversarial is we want the best possible health outcome for the injured worker. We want it, the injured worker wants it, the claimant's attorneys want it, and we're just looking at a method, a process, and a way to deliver on that. And if we can do that, we're all going to win. And it does take the conflict out of the process. So I look forward to working on the items that have been identified, working with our staff, and working out a better way of getting second opinions and these independent medical opinions from our consulting doctors.
Okay, thank you.
Okay. Hi, this is Winston Kwa. I'm a practicing occupational medicine physician at Mount Sinai Hospital. And I think I like this list. This is a very comprehensive list. I think it addresses a lot of the shortfalls with the current IME system here. And with slide 18, as you can see, there's just a far few physicians or providers that are actually doing IMEs and providing these second opinions who may not be as well versed in providing care. As a practicing physician, I have to stress that I think as a treating physician, the treating physician knows the injured worker better than these IME providers. I think a one-time visit is not enough to provide enough information in terms of the degree of disability and the severity of a condition at that one-time visit. I think you should look at what the treating physician's notes are over a long period of time to actually determine what a degree of disability should be, because it can change over time. On some days, we were talking, on some days a person can have severely limited range of motion, while other days they could be perfectly fine and have mild degree of limitations. And that could be on a day-to-day basis. So it's so hard for an IME to gauge on that one-time exam based on that one like maybe 15-minute exam on that degree of disability, while the treating physician can see this range and it may be documented in their notes. So I think IME should be used as, like what you said, a second opinion. As for a second opinion, but more weight should be placed on the treating physician's notes and documentation. And I think that's my only opinion for now. But I'm glad to work with everyone on this project.
Thank you. Thank you.
I'm Rick Weinstein. I'm a practicing orthopedic surgeon in White Plains. First, I want to thank you for making this available where I didn't have to go up to Schenectady. My son is at College of Union, which is in Schenectady. I could have visited him, which would have been nice, but not this time of year. So my thoughts on IMEs. I do IMEs for my patients, and I do independent IMEs for carriers as well. I do about 200 to 300 a year, which is what I thought was a lot until this was put out there. And I'm very concerned with those 2.5% who are doing the majority of IMEs. If you calculate those 10 doctors, if you say they do an average of 6,000 IMEs at $500 a piece, that's $3 million that these providers are collecting themselves. They're not going to be fair reports. They're not going to be good reports. They're going to be IME mills. I'm very concerned as a practicing orthopedist about the mills, about the treatment that these physical therapy, chiropractors, orthopedists are in these mills where they just turn the patients in and out. When I see a person for an independent medical exam and they say, I've been treating for 6 months, I'm not getting any better, it doesn't help, I go 3 times a week, 4 times a week, sometimes 5 times a week. I don't know why these places have not been shut down. It's very upsetting to me because it's a waste of everyone's money and time. And these IME doctors, I don't know if they're doing appropriate exams and not appropriate exams, but I think that we have to address this 2.5% of IMEs that are being done. The only other thing which I wanted to question, I don't know the answer to this, is if you're doing an independent medical examination, you're not a treating physician. If you're doing that IME exam on that person and they say they got hurt, your malpractice will not cover you. Who covers you if you get sued by a patient or not a patient if someone says they got hurt doing an IME exam? I know we have a bunch of lawyers in the room. I don't know if anyone wants to touch that.
Nope.
Said that awful quick.
That's my thoughts.
Okay, thank you.
Thank you.
All right, so, one of the things that I took away from the conversation was there were no issues on the list that people didn't want to discuss, which leads nicely into the
May I correct
aggressive.
you?
Okay, go ahead.
The injured worker treating piece, I said was
Okay.
beyond the scope.
Okay, thank you.
If I could just say something about that, I think the purpose of that is because there's an issue of weighing the credibility of the IME exam versus the other reports. So it's not to get into the scope of what a treating provider could do. I think it's really reference purposes only. I'm just noting that it's the committee's decision.
From my perspective,
Okay.
it's beyond the scope.
Actually, I thought, the reason I didn't add anything is because I thought that injured workers treating was so important, and I was glad to see it there. And I don't think it's beyond the scope to the extent that I don't think you can really discuss IMEs in a vacuum. I think you have to really look at the entire system. And as it was pointed out earlier, IMEs are created primarily for evidentiary purposes. And so where does that need come from and why? So I think you can't look at them, again, in a vacuum. You have to look at C4s, at treating physicians, what that process is like, and what creates the need, or why are we getting IMEs to begin with. So I would respectfully suggest that this stays on the agenda.
Okay. So it's clear we have a number of things to discuss, and we do have a statutorily required report that is due by the end of the year. And so what I believe we mentioned earlier, our goal would be to schedule for all of us a meeting a month, which, will be focused at each and every meeting on the topics that we had delineated, to talk about them and flesh them out more thoroughly. By then you will have seen some of the results from the report. So what we're proposing is essentially for each meeting moving forward, including today, we will review the agenda and the agenda topics for the subsequent meeting. We'll briefly review the IME utilization study data for the topic that we are going to be studying that meeting. We'll discuss agenda topics in detail. Hopefully, we will reach consensus wherever possible, and where we are not able to reach consensus, we will memorialize that with the differences of opinions between all of you and why we can't reach consensus. We'll discuss the agenda topics for the next meeting, and to the extent that we need to identify supplemental data that you may request, we will work with the staff to gather that and present it at each of the following meetings. So that's kind of, what we're thinking. What we had thought would be potentially the first meeting would be sometime in March, and where we would talk about would be providers, which seems to be one of the things that people were not most interested in, but we figured that would be a good place to start. I know some of you had mentioned purpose as potentially a topic process. So I leave it open to the group as to what that first meeting discusses. It's your committee, it's yours.
Does anyone want to second that suggestion, or you think it's fine to leave it as is?
Go ahead.
I think that putting process last informs the discussion on process. I think all of the preliminary items on the list will inform that discussion at the end.
Okay.
I agree with that.
I was going to second Brian's notion and his belief that managed care will be helpful. I actually do also agree that it will help inform that conversation once we flush this out.
Okay.
Okay.
Joe, did you want to add anything?
Not about the sequence here, but now we're going to talk about providing doctors and managed care as part of this. I mean, this, to me, maybe we should ask for another year from the legislature if we're going to start adding, you know, this, if this is going to turn into a, you know, an unlimited workers' comp, you know, rolling workers' comp discussion, then so be it. But we won't make it by the end of this year, probably even next.
So, I mean, I hear what you're saying, Joe, and I've heard you say it before, you've heard me say the things I've said. It's impossible to discuss IMEs without discussing process. It's impossible to discuss process without discussing at least the alternatives that exist. So if you want, I'll gladly go to the legislature with you to extend the time period on this.
The idea that care directed by an employer or a carrier is the only way to improve care for injured workers is anathema to me.
Now that's outside the scope.
Well,
right?
you're talking about PPOs and managed care and directing care, so I feel like I should be able to as well. If you want to agree that this is beyond the scope and we should focus on
I don't agree that
IMEs,
it's beyond the scope. I was
then I'm happy to stick to IMEs. But really, let's be honest about what's going on here. Most of the employers are corporations. Corporations function to maximize profits for their shareholders. So the idea that I mean, basic biz orgs. That's basic biz orgs. You know, the notion that what's best for the injured worker is that, you know, at heart for everybody is nonsense. So I think that we should dispel that. I think that there are good employers, folks who are involved here, folks who want to help their workers without question. But the idea that we should just give it over, give care over to the employer is going to, when you look at the system as a whole, is going to hurt injured workers and is going to limit the cost of care before it increases or enhances the quality of care for injured workers. So I'm just saying it's a slippery slope, and if we're going to go down it, then we're going to go down it. But it's going to bleed into other things, and it's going to bleed into benefit levels. It's going to bleed into care. I think it's beyond the scope.
So a couple of things. First and foremost, I'm not certain that the majority of employees in the state of New York even work for-profit entities, but that notwithstanding, those that are for-profit entities absolutely do care about the health and the safety and the ability to get better of their employees. Absolutely, without question. Are there bad actors? Without question also. The majority of employers are far from bad actors. Brian Trick represents an employer that I don't even know how many employees you have in the state of New York, but it's a lot. I would say that you are an absolute standout nationally for a company that cares about its workers and cares about their health. So to suggest it is problematic. But there's simply no question that if we don't have the opportunity to discuss the different options vis-a-vis IMEs, vis-a-vis them disappearing, then we're leaving a lot on the table. So I'll reset it. You suggested that we go to the legislature, we ask for more time, and perhaps we alter the scope. If you'd like to do that, I'm offering myself to you as the business council. We could go together and we could ask for an extension, and we could work on this for as long as it takes, and wherever that slippery slope takes us, we could do that.
Excuse me. I think actually the legislature has given us a charge, and that's to look at IMEs. And the format that we take moving forward is, as I said, you know, really going to be dependent upon your input into this process. And if we can't get over this fundamental hurdle, then clearly we have a problem. However, I do believe that the report can include a recommendation to agree to disagree. You know, there are clearly a number of issues, as you will see when you read the report, as Stephanie walked through on the details. There are clearly some problems with the existing process. We can talk about those, understanding that there may be a fundamental disagreement between whether or not we want them or not. You know, that could be beyond our scope. So, again, I leave it open to you. This is your group. But I think there is a lot of good work we can do, and we can start with process, we can start with providers. You can't look at the provider slide and not say there's an issue there. So,
Mindy, did you also have a comment?
I'm sorry, Mindy.
I just wanted to say, I think that whether or not anybody has to go to the legislature, we can save that for another day, because the truth is, let's see how much we can get accomplished up front.
Agreed.
And when we're in October or November, we can, see how we're doing. In terms of process, I tend to agree with Lev to the extent that, first of all, I think it should come at the end, because I think at the end, we've fleshed out all these issues beforehand, and that'll inform the result. But to say that one particular result or another is off the table today seems to me to be premature, Joe.
So the process, this is not a conversation about process. This is a conversation about handing over the ability to direct care to employers and insurance companies. And I don't think there's any dispute here that that's what this is.
I don't think that's what this is
The
about.
committee hasn't agreed to that yet.
I'm suggesting that this is the reason why Mr. Trick brought it up. He said direct care, the difference
Because he
between where
believes
they
in it,
can.
and his firm
Yes,
does
and,
do that.
and I get it, and I get that.
But
But
that
if that's
doesn't
where
mean-
we're going to go here,
No,
It
I think.
doesn't-
if
No,
that's
I
where
don't
we're
think
going
it's
to
that
go
bad.
here, right? Then we're going to only compound the problem of those 2.5%.
We don't want to do
Because-
that.
Well,
As an employer in
if
the state of New York, I can tell you for a fact, I don't want to compound that.
well, then we're in
It's
agreement.
very challenging for us to find IMEs that we think are doing the kind of IMEs that we want to see full, truthful, and accurate IMEs. So for us to have to be reduced to using that 2.5%, because that's what's available to us, is problematic. That is not the results we're looking for in the least. So I think the fair thing to do is to not prejudge anything or anyone. I know that I am sitting at this table in full and good faith. I think there's a problem for lots of reasons, in lots of ways, and I'm here to try to resolve some of them. And I think we all are as well. And I don't think it's fair to prejudge the result beforehand.
I'm not prejudging a result.
I think
If we hand over the ability to direct care to employers and insurance companies, that 2.5%, instead of just being IMEs, we'll be looking at that 2.5%, and it'll be the treating doctors. We won't have any more IMEs because the treating doctors then are paid directly by the employer.
How is that even possible under the legislative mandate?
That's all I.
It's, this committee doesn't exist.
This is my point. Is that directed care is beyond the scope.
You're talking about handing something over as though it's something you have control over and you own to hand over.
Or we.
Or we own to hand over, and we just don't. The only section of the statute that was added was the last subdivision of section 137, independent medical examiners. Nothing about managed care, nothing about PPO.
Which is
Then we're in agreement.
I agree as well that the legislature was very clear in the mandate for this committee and the statutory language that they used. And as we all know, the language of the legislature is presumed to mean what it says. I don't believe this committee has the ability to make any recommendations in terms of treating providers or what might be the future of those. And if the legislature had intended us even to discuss that issue more than in a bare contextual matter, it would have said so.
I don't know, I think that you can't create, I'm sorry.
No, go ahead, Mindy.
I don't think we can have this conversation in a vacuum. I think that what we should all, for me personally, I think the way to approach this is to say that we have a concern and an interest in doing the right thing by injured employees, in ensuring that they are able to get the best possible health care, that they're able to return to work appropriately. I don't understand why we can't all agree to that and say, what's the best way to achieve those goals? And if that includes, in the context of IMEs, saying, well, what's the alternative to this IME system, and why is it not working for everybody? Why wouldn't you want to go there?
Can we weigh in from New York?
Yes. Go for it, Doctor. You always.
First, go.
So I would just say, and I think those of you that have worked with me, I guess I'm guilty of always trying to be a consensus maker. I would just say that the discussion of directed care in this context is probably a solution before we understand the problem. And perhaps I would suggest, and I don't know that all my colleagues on the call will agree with me, but perhaps we should table this discussion to move forward with identifying the problems, because I think there will be a lot of agreement around the table about the problems, and when we talk about solutions, we can come back to arguing about whether a particular solution is within the scope of the legislative mandate to discuss. So I guess I'm partially agreeing with Joe that, talking about directed care today is discussing a problem that we have not yet identified exists vis-a-vis IMEs. But at the same time, if we identify part of the problem with IMEs is they're required, I'm just surmising, there's certain problems with IMEs that potentially directed care could assist with. I think it would also be foolish to not include that in a final report, even if it's a minority opinion. So that's my 2 cents. I don't know if anyone agrees with me, but
I would just add, with due respect to all parties, I think other sections of the statute would need amendment before anyone could begin down that road.
We're not even near there.
Okay.
Okay. Dr. Goldberg, did you have a comment?
First of all, I hope I have time to go to law school between now and the next meeting. As you can see, I have to do that. But I want to talk about the word process, and the suggestion was made to put it last. In order to understand timing and scheduling, in order to understand what the responsibilities for provider are, and then for physicians, to talk about how cost might be derived, and certainly fraud and abuse. I don't see how we can discuss fraud and abuse unless we see what the process is that leads to it. To put process last is really, in my mind, what the recommendation of the report is going to be. But I believe we need, and I'm going to make an argument, to start with process so we know what the circumstance, what the situation, the architecture is that as of today, and know how these pieces fit in it so we can make recommendations as needed as we go along. Otherwise, we will find ourselves changing timing and scheduling, the experience and providers and cost and fraud and abuse, only to then have to go over them all again when we have processes to discussion. So I would like you to think really long and hard. Let's talk about what it is now, how it is, so we know where we can all identify from personal experience and from the consensus of our groups what it is. So I'd like to start with process.
Okay.
Thank you.
So that's a second for Brian's suggestion. Does anyone else want to weigh in on whether or not we should start with process? Was anyone compelled to go one way or another? Is there a consensus, or should we leave it as is? Doesn't appear that we have consensus, but go ahead.
I think I've already stated
Yeah.
my opinion that process should be last.
Okay.
And can I say one thing? This is Brian in Rochester. To Joe's concern, and that certainly is a concern we all know about and probably some of us agree with partially, is that direction of care. And that's something the report can come out with, is maybe it's not direction of care by the employer or carrier, maybe it's the work comp board creates the panel, so it takes all that adversarial piece out of it. That's something that we should think about, but having panels to choose from really drives a lot of things. I know probably too early to talk about it, but I saw it on the list, so I put PPO on there, so I thought I could talk about it. Probably shouldn't have, but it saved us about half-hour time. So I saw my opportunity, and I wanted to strike because I didn't want to miss my opportunity. But I think we can talk about as far as what the process looks like. It doesn't have to be direction of care. It's just panels of providers that specifically treat workers' comp is what we should be shooting for.
Okay.
If I could just add one last thing, in an attempt maybe to move this process last question forward, at least as far as I'm hearing and understanding, and maybe I'm wrong, perhaps, recommendations on change to the process probably should come at the end after we've gone through, but perhaps in the beginning there should be some discussion of the actual, what is the process, how does it impact providers, et cetera, maybe earlier on and so maybe there are two kind of components to the process. What is it today and how does it impact providers, timing and scheduling, which is kind of part of the process, but then I think at the end is appropriate to talk about revisions to the process.
Yeah, current state, future state, I like that idea, Jeff.
Can I ask a question? Did
Yes.
you mention that there was some information about various states and how they approach this issue?
Yes, that'll be in the utilization study for you to review.
Okay, because
Absolutely.
actually, in light of what Jeff's saying, maybe that would be a sort of a good beginning, early process part to see what other kinds of systems and processes there are out there, and then revisit it when we want to sort of make determinations as to what our own conversations lead us to. Okay.
Yeah, so you'll have that in the report that you'll be handed today when we leave here. And I'm not sure exactly where in the agenda, but let's look where we were going to look at other states. But if other people feel similarly, we can move that. Yeah.
All right, maybe something a little easier to decide is the next meeting date. What we're suggesting is maybe every second Thursday of each month. And again, the idea being that you schedule these as close to that date as possible, if that works for people. The next first meeting would be on March 14th.
Why are we switching to Thursdays?
This is the date
Why not?
that works for
Because
most.
Thursdays seem to work, especially for those folks that need to be in the Capitol, particularly in the month of March. I know
Yeah.
Thursday works.
Something like third meetings, right?
Well, some of the months have a conflict on that second Thursday with rating board meetings, but I know some of our advisory committee members they participate in that, so.
Thursdays in general, I'm in surgery, so it'd be difficult for me to make it Thursdays.
Oh, I see.
But just one person, so.
For the rest of the group, would Thursdays be okay? Understanding that there would be times we would move it to a different day so you could be able to attend, and when you couldn't, you could send a delegate. Would March 14th be the next best day?
I'll be in Chicago, but I'm one person.
Okay.
Is that Thursday afternoons?
Yes.
Is it possible, that was what I was going to make it from, instead of from 1 to 4, to make it from 12 to 3?
I'll defer to
Because
staff
the
here.
train schedule is much better that way.
Oh, I see.
If I want to come up.
I can't.
All right. Back to the original question. Does March 14th seem to work for people? And then we'll figure out the times. Yes? Okay. And then moving forward, the schedule would kind of look like April 13th, May 8th, and we'll send you all these dates. April 11th, I'm sorry. April 11th, May 8th, June 13th.
May 8th is a Wednesday.
Yeah, May 9th.
We moved it, like I said, we moved some of them around a little. And, and then we'll continue through the rest of the year, at least meeting once a month on that second week. So we will send you all of those dates. Our goal is to have the draft report done by November, with the understanding that the December meeting will be focused on the final report, whatever shape that takes.
Who's going to be the writer?
Ms. Pierre will assist in writing, but you will have the ample opportunity to review and comment.
If there is a disagreement about what goes into the final report, is there a structure for voting that the committee will have? Is it quorum present, majority vote? How will that work?
We hadn't actually talked about that, but
It's a good thing to flesh out.
it's a good thing for us to flesh out. I wouldn't be at all surprised if, you had two different opinions that were reflected in the report based on who it is that's representing the folks.
And if that's the way that the final report is to be written with disagreement in it, so be it.
So be
I defer
it.
to the committee. If we wanted something cogent, then we need a little more formal of a structure, probably. That's all.
I think the opportunity for a dissent in writing, whatever goes to the governor's office might be a good idea.
Yes, sir.
You just put that which we're unanimous about in the report.
Fair enough as well.
Also,
Exactly. But, we could, we'll clearly be talking about this as we went down.
Okay, so as we wrap up, as we mentioned at the conclusion of this meeting, you'll be receiving the utilization report, and those are appearing remotely will also receive it shortly. So please review it thoroughly. You're going to have all of the slides that we've included in the PowerPoint presentation are there and more. It's a very extensive report. Stephanie and her team really did an excellent job compiling all this data and making it very digestible for all of you. So I think it'll be very interesting reading for you. And when you return, we will address those questions in detail that you may have about the report. And as Michelle was saying, the next topic will be provider access, including, and this is where you'll be able to raise any concerns about adding something to the agenda, something that we may have missed. We understand that, you know, the 15 or so minutes that we gave you today may not have been enough time, but you'll have some time between now and then to think of anything that we may have missed in this topic. At the next meeting, we're going to start with a brief overview of the provider access data in the utilization study. And again, we'll answer your questions. Next, we'll discuss the provider access concerns and try to reach consensus on how to improve the system. We will close the meeting with a confirmation of agenda topics to discuss at the next meeting on scheduling and timing concerns, as well as any additional data requests that may be helpful to gather for that meeting. And again, if we need to move any meeting topic around, you can suggest it. If there's consensus, we'll do so. It's not all necessarily set in stone. So thank you, everyone. We look forward to many productive conversations with all of the committee members around the table as we work to improve the IME process within the New York State workers' compensation system. Thank you so much for being here. We're going to go ahead and hand out the report now.
Thank you.
Thank you very much. Oh, one last thing I should mention. This webcast will be available tomorrow, as well as the report on our website.
Oh, maybe not.